On the phone, it's a pleasure to welcome to the program senior editor at the New Republic, Noam Schieber, on his piece, The Case for Socialized Law. Welcome to the program, Noam.
Thanks for having me.
Give us a sense of what the need is for socialized law before we go into what that actually means.
Yeah, so, I think it will surprise no one for me to point out that there are pretty vast inequities in the legal system. I can throw out a number of anecdotes, number of statistics. I mean, the one that was most glaring to me as I did research for this piece is if you look at the number of legal aid the number of people served by a legal aid lawyer, number of poor people, it's about 6,000 people per legal aid lawyer in this country. For the private sector, for private lawyers who deal with similar problems for non-poor people, it's about a tenth of that. It's about one private lawyer for about 500 people. So, if you just look at the raw numbers, legal aid lawyers are handling about 10 times as many, clients or potential clients as people in the private sector. And that's just on the civil side. I mean, if we look at, criminal cases, public defenders are, similar ratios, if not larger. They're just overwhelmed by the number of cases that they have to deal with. Whereas, you could pick your famous, defendant, white collar criminal defendant, that can afford tens of millions of dollars. I mean, one in legal expenses, the one I seize on in my piece is a very famous one, Jeff Skilling, the former CEO of Enron, who spent upward of $75 million in his own defense. And,
I saw that in your piece, and that blew me away. $75 million on a team of defense lawyers, and the amazing thing is, it was worth it for him.
It was. I mean, he originally got something like a 24-year sentence, and he got it basically halved after his lawyers, kind of scoured, legal libraries worth of texts to find kind of flaws in the government's theory when they prosecuted him, and the Supreme Court eventually bought it, and a lower court judge found a flaw in the sentencing, and his sentence was halved. He's serving less time than a kind of average nonviolent drug offender. So explain that to me. So look, the inequities are pretty vast. And historically, the remedy that's been proposed has been...
Well, hold on. Let me, before we get to the remedy, I want to just sort of parse this out just a little bit, because we're talking about both the civil side and we're talking about the criminal side. And when we also talk about legal aid, there are basically two systems for this. There are a state system and a federal system. And when you cite those federal statistics, that's even better, I think, than what we see on the state system, because the state systems have been cutting back dramatically, particularly over the past 4 or 5 years on legal aid. There's no, there doesn't seem to be really much of a statutory compulsion to maintain those lawyers. Now, let's just talk briefly. Like, what would on a civil side? What are we talking about in terms of cases? I mean, criminals, it's fairly somewhat obvious, I think. But on a civil side, what are we talking about?
The kinds of cases, it could be anything from someone wrongly evicted from their house, someone wrongly fired from their job, a discrimination claim. It could be a coal miner pursuing a claim for black lung, any kind of occupational safety issue, injury on the job. It goes down the list. Up to sort of, class action suits where something like the chemical spill in West Virginia, where you would want to bring action against a corporation that flouted environmental laws. Now, part of that could be brought by the government, but there would be civil claims involved in that too. So it could be anything from the very small to you dealing with your landlord to something very large. A kind of a wrongful death thing, or poisoning. At the hands of a corporation that was negligent.
Now, we should say that when you talk about something like the I don't know, the myriad now, the multiple spills in West Virginia, you're talking about a class action suit where you are much more likely to get a private trial lawyer who is then incentivized by a large class action settlement where they will get their pay basically as part of that settlement. And so there's a couple of forces here that people should just be aware of, that when we see sort of changes to the law, like for instance in California, where certain groups are barred from filing class action claims, it becomes economically unviable for these people to get representation. If you're just a single person with a small claim, it's much harder to get representation at that point, because the amount of work that goes into this, if you can't pay for that up front, your settlement may not actually equal what the cost would be. And so that's when you need some type of legal aid services.
No, that's exactly right. And even you said it exactly right. The sort of plaintiff's bar has traditionally been the way that people without resources to spend up front get some form of justice. But even in that case, it's far from perfect. You have to basically persuade the lawyer that to spend his or her own resources, which can be considerable up front. And if you had those resources to spend yourself and weren't relying on the lawyer's good graces to do that for you, you might move ahead in different cases. So even that has been, while useful corrective, has been imperfect, and as you say, it's being restricted in various jurisdictions as we move forward here.
So let's talk about sort of the history of the development of things like legal aid, like federally funded or state funded. Essentially, the state, the government actually sort of providing funds, as anemic as they are. But what was the theory behind this? I guess in general and specifically in this country.
Yeah. So this kind of came about in the late 19th century, and you had basically private philanthropists, businessmen, sort of prominent local citizens in various municipalities. Sometimes immigrant communities, leaders of immigrant communities would do this. They all sort of realized that it's not a sort of stable long-term proposition for people to feel as though, particularly poor and working class people, to feel as though justice is rationed. And in the late 19th century, it was very easy to feel that way. Poor people, working class people would get screwed constantly, by employers, by loan sharks, by all sorts of kind of hucksters and shysters. And it became very obvious that if those grievances couldn't at least occasionally be redressed, that people were going to get very upset, and this could sort of explode, at some point. So you end up having these philanthropists come together on a kind of local level and fund legal aid legal aid organizations that would take these kind of small-time cases, someone dealing with a landlord, an exploitative boss, someone running a sweatshop who just refused to pay their employees, it was important and useful and did some good for people, but there are a lot of limits on this, and the limits were often coincidentally on claims that would challenge the interests of the businessmen who funded these legal aid organizations. So the example I use in the piece is the legal aid lawyers would very rarely accept a work on behalf of people who wanted to declare bankruptcy, and instead they would sort of counsel them how to scrimp and save and eventually pay off their liabilities, and that wasn't an accident. A lot of the people who were funding these clinics and these organizations were people to whom money was owed.
Right.
And if on a large scale you started encouraging people, or at least making it easier for people to declare bankruptcy, then they were going to be left holding the bag. So it was altruistic to some extent, but I like to describe it more as kind of enlightened self-interest, and it was a step forward, but it was a modest step forward. And really, it kind of in the Western world, sort of the rise of the welfare state starts to happen. In England, Germany, in the 10s, 20s. In this country, is a response to the Depression, mainly in the 30s. And people start to realize that, private philanthropy, for all its virtues, is just, ill-suited to the task of dealing with people's needs on a large scale. And, certainly the Depression drove that point home for us in this country. And so you start getting murmuring, certainly, of healthcare needing to provide healthcare on a larger scale, economic relief for people who are unemployed or can't find jobs or even can't feed their children. And then, as part of that conversation, people start to think, well, people have legal needs. The world is becoming much more complex, and often lawyers need to be tapped to help people navigate the world. Should we not be providing some aid for legal services as well? So that conversation kind of starts, I would say in the 20s and 30s. In this country, lawyers, the legal profession, the American Bar Association starts to realize that this thing is kind of potentially coming down the pike. Kind of in the 40s, there starts to be a conversation among lawyers. I cite an article written by the head of Duke's Legal Aid Clinic, Duke University's Legal Aid Clinic in 1945, where he says, look, fellow lawyers, the natives are starting to get restless here. If we're not careful, we're going to get socialized law in this country. So we, if we're smart, should just try to expand, private philanthropic legal aid services on our own to sort of preempt this, head this off. It kind of, that effort sort of, there's some marginal incremental changes, but it doesn't really go anywhere. So finally, you get to the 60s and the Great Society and under Lyndon Johnson, and there's this big impetus as part of the Office of Economic Opportunity, the War on Poverty, to do this for the first time on a federal level, and that's the first time it happens on a large scale. First, they created this office, within the White House, the Office of Economic Opportunity. Eventually, they create a separate entity called the Legal Services Corporation in 1974. Richard Nixon, of all people, signs that into law, and we fund, an organization at the national level. It basically makes grants to existing kind of local and state level organizations. And, the American Bar Association was very smart. They saw what happened when doctors kind of went to war against Medicaid and Medicare, and they saw that the medical profession basically lost any ability to influence this. And so they decided they were going to kind of play ball and engage, and that allowed them to kind of keep it sort of limited, keep control over it. Again, it would be the federal government sending grants to local organizations, often which were often dominated by kind of local bar associations anyway. So they were able to really keep tabs on this pretty well.
What was the hesitation of the American Bar Association? I mean, where I can understand from a doctor's perspective.
Sure.
The threat is that we're going to have our expenses, our fees
Right.
capped in some way.
Right.
What happens? What was the impetus by the ABA at that point?
I think partly it was just a kind of ill-formed ideological objection. They thought they were doing fine on their own, and the heavy hand of big government could disrupt their mojo. But the more specific concern, I think, was just some kind of regulation, and then forcing them to accept clients, for just kind of well below market rates. I think so. In some sense, it was kind of an analogous concern.
But there is nothing like that, though, right? There is no sort of forced pro bono or near pro bono work that an attorney need do at this point or at that point.
There is not. No, interestingly, there was one small component of, and it sounds almost kind of farcical, but there was one small component of the law that enacted the Legal Services Corporation in 1974. It's called Judicare, and it's basically what it sounds like. It's like Medicare for lawyers. And the idea was that if you had some kind of legal matter pending, could go to a lawyer, and if it was deemed meritorious, the lawyer would act on your behalf and then just bill the single payer, which was the government, and the government would pay the bill. So it was a kind of Medicare for legal services. It was a small thing. I think the Bar Association didn't love that idea for the same reason the doctors didn't love Medicare, and they were able to keep it, on a pretty small scale. And it kind of just fizzled out because it just didn't get a lot of uptake. People didn't really know about it. The lawyers weren't really in love with it. So that was kind of the sort of Medicare equivalent, but it never really went anywhere in this country. In England, it actually did. That was kind of the way the British did it, beginning in the late 40s. And at one point, 80% of the British public was eligible for that. So this was something that was not just kind of seen as a welfare program. It really covered most of the population, and there were a few decades in which it was really kind of a strong, vibrant program.
All right, so we have this. So that's basically just sort of the history of how this evolved, and we know. I mean, you cite this case of the affluenza as a sort of an example of the discrepancies or the ability of one to be able to buy better treatment under the law, right? I mean, just walk us through those two examples that you contrast.
Yeah, so this affluenza case is, got a decent amount of attention. It's this 16-year-old in Texas named Ethan Couch, affluent family. He took his father's pickup one night, stole a couple of cases of beer from Walmart, got drunk with his friends, went joyriding down the highway, killed someone who was broken down on the highway, and 3 passersby who had stopped to help that person. So he killed 4 people while he was drunk and joyriding on the highway. The family hired 2 prominent local defense attorneys. They, in turn, hired a psychologist to serve as an expert witness. They put together this elaborate defense. Affluenza was the malady to which they attributed his crimes. And the idea is that if you are coddled by wealthy parents, you just aren't able to take responsibility for your actions because they've never taught you how to do that. The judge, there's been some controversy over how prominent that loomed in the judge's deliberations, but what we do know is that the judge did not sentence him to any time, sentenced him to 10 years probation and 1 year. He agreed to spend 1 year at a pricey rehab facility in Southern California. I think the price tag is $500,000 a year. So the affluenza defense was wielded. As a practical matter, it was effective. He served no time. 10 years before that, there was another, poor kid in the same area in Fort Worth, Texas, a suburb of Fort Worth. He stole a pickup, went on a kind of bender in the same way, ended up killing an innocent person. He did not have the money to afford his own private lawyer. Was appointed a lawyer by the court. They went to trial. He actually pleaded not guilty on the lawyer's advice, which a lot of lawyers think is a bad idea because they call it a trial tax. If you go to trial, then the judge is likely to be harder on you. They went to trial. He was found guilty. It was the exact same judge who sentenced him as sentenced Ethan Couch in the affluenza case. He got 20 years, and not a lot of mercy shown him by the court. He was same age, 16, very similar crime. And so, it's obviously it's one anecdote, but it's a stark one, and it's just hard to believe that had he had the resources that Ethan Couch had, the kid who got off, that he could not have had handled his case a little more, with a little more dexterity. I think everyone tells you basically you want to plead guilty and throw yourself at the mercy of the court, and the affluenza kid did that very, very well and had a lot of resources to do it. Interestingly, I talked to the lawyer who represented the other kid who got 20 years, and obviously he feels he sort of defends his decision to take the case to trial. But the one thing he does say is it's absolutely the case that you feel the resource constraints when it comes to expert witnesses. I mean, they can be very helpful in these trials, and if you are relying on the state to fund your defense, you have no money for expert witnesses. So, if nothing else, the ability to spend thousands of dollars on an expert witness, I think is an important difference in the two cases.
Right, and that case is illustrative, I think, of a dynamic that people just sort of sense exists. I mean, if you don't, if you come into a court with half a dozen attorneys and backed by a big firm that you're spending millions of dollars on, you're going to end up getting a better sentence than if you hadn't. I mean, at this point, we almost sort of accept it for, I guess, just sort of like we do gravity on some level, right? I mean, this affluenza case is that much more sort of just shocking because of I think maybe in some ways just that defense. And this dynamic also works in these civil cases. I think we probably see it all the time when it comes to sort of like tenant-landlord situations.
Yeah.
I mean, I guess a whole myriad of stuff that ranges from something that small to when you've got a single claim against a big corporation, they can just draw it out forever because they have just, all these lawyers on retainer, if not working within the company itself.
Yeah, no question about it. I mean, one other statistic that I talk about in the piece is and I alluded to it earlier, coal miners who file black lung claims. I mean, there are, in a typical year, I think about, 4,000 or 5,000 miners who file these claims. Typically, fewer than 15% of them are successful, and it's not like you have a lot of coal miners running around West Virginia and southeastern Ohio, inventing black lung. I mean,
right.
The idea that there are fewer than 15% of these guys who got black lung, from working in the coal mines for decades. The idea that they're inventing these conditions or they're maybe psychosomatic or something seems very hard to believe. So yes, there are some pretty obvious situations in which it's very hard to imagine that more sophisticated legal representation wouldn't pay large dividends.
So when we look at this, and to a certain extent, right, the existence of legal aid societies, government-funded legal aid societies, is in part conceptually is socialized law, but this is inadequate, obviously, for the reasons we've just been talking about. So your proposal is what?
Yeah, so my proposal is twofold. I mean, one, you would want to sort of vastly increase the funding that is available in both these criminal cases and civil cases. I mean, if the legal aid lawyers that you talk to, as I have, think that expert witnesses would be very helpful to defendants in criminal cases who have to rely on the state to fund their defense, then we should make it possible for them to pay for expert witnesses as well. It seems insane to me that you would only make that available to the affluent. But so I think clearly we could be spending a lot more money to ensure that people get have a reasonable chance at a just outcome. But the other dimension to this that I think is important and I think strikes people as probably pretty radical, but it's sort of hard to get around the logic once you think about it for a bit, is to limit spending on the part of the very affluent. And the reason I think that's important is it's not enough that we guarantee everybody kind of an adequate or sufficient level of legal representation. The way I think most liberals would think it is enough that we guarantee people an adequate or sufficient level of education or health care. I mean, most liberals would want that level to be very high, as I would. But they think, if you provide people with a high floor of education, of health care, housing, that you have done your job. The state has done its job. I don't think that that is something that the logic applies to legal services, because what we strive for in the law is really equality in the eyes of the state. We should all be equal citizens. We should all be equal in executing our rights. And if that's the case, then even if you have a high sort of adequate level of legal services or even a high level of legal services, if someone who's fabulously wealthy can come and spend 100 times, 1,000 times the amount that you can in, say, fighting a criminal indictment for the same crime, they are able to effectively buy more justice, and you are not equal in the eyes of the state. So if this notion of kind of equality in the eyes of the state, due process of the law, equal protection of the law, or just basic rights of citizenship, if that means anything, I think you have to do more than just provide a minimum bar, even if that bar is set very high. It really has to be pretty equal. If you accept the assumption that more money effectively buys you more justice, which, as we've just been discussing, it's hard to sort of disagree that it does on some level. And we can disagree with maybe the returns diminish at a certain point. We could argue that, but if you accept the premise that more money buys you more justice, it's very hard to allow these sort of vast inequalities of spending to continue. The analogy I think is that's more appropriate is really like voting. We all get one vote. It's important as citizens that we are allocated the same say in an election. And if someone who was very wealthy suddenly got 10 votes to your one vote or 100 votes to your one vote, it wouldn't be a sufficient kind of rationale to say, well, you got an adequate number of votes. I mean, they got more than you did, but you got a sufficient number of votes. You got your one vote. The fact that they got 100 times the votes that you got would diminish yours, right? So in the same way, if the goal here is equality in the eyes of the state, that we're all treated equally as citizens, the fact that someone can buy 10 or 100 times the justice, it diminishes your status as a citizen when that happens.
So all right. So it's, I mean, on one level, I mean, for me, in the civil, in the area of civil law, this seems even more self-evident. I mean, because we have an adversarial system, and it is necessarily a zero-sum game. If somebody's going to win, somebody's going to lose. If someone comes into what is supposed to be an equal process, but comes in with more essentially ammunition into that process, it's tilted. I mean, it's all, I guess, sort of like on every case is on a bell curve, I guess, on some level. And on the criminal justice side, the dynamic is slightly different. It's really about how everybody enters in, and I'm just trying to clarify here, as everybody enters into the criminal justice system, they have the same opportunity. The law is always the same for them. So it's not just a matter of buying more justice. It's also your ability to buy more injustice in some way.
Exactly right. And if we want to feel as though the legal system is not arbitrary. People have to have, different people in different circumstances have to have basically the same shot of vindicating themselves if they're innocent, and basically the same chance of going to jail if they're guilty. And that's just not possible if you have sort of vast inequities in spending on legal representation. Even if certain people, even if we were to ensure somehow that everyone had an adequate level, right? So, say we were able to vastly increase the funding for public defenders across the country, and we were, we felt pretty good about the services we were able to provide. But, you still had very wealthy people who were able to spend 100 or 1,000 times that. You could not say with any confidence that the person who's relying on a public defender and the fabulously wealthy person who's able to outspend them by orders of magnitude still have the same chance of going to jail if they're innocent and indicted for the same crime, or the same chance of going to jail if they're guilty and indicted for the same crime. It's just not possible, right?
Well, and now this is the moment in the piece where I was like, well, wait a second. One of the big problems we have is not just sort of how people enter into the justice system, but it's also the application of justice when a prosecutor decides to bring charges. And in this era that we're living through now, I think it's sort of and that seems to be a major part of this. If you're if you're Jamie Dimon, if you're or if you're if you're J.P. Morgan Bank, it's you're not going to go to jail. It's just a business expense essentially.
Yeah.
And address the critiques of what you're saying, because that is one of them, and the other is sort of more of a practical one. But address both those, because I think this part of your argument I think is also really important, and it speaks to sort of the broader agenda, if you will.
Yeah, look, there's no question, you can make a criticism of my piece from the left, and I think it's a valid criticism that by the time you get to legal representation, a lot has already happened, right? The whole construct of the legal system and the laws and sentencing and who gets prosecuted for what, that reflects sort of a disparity in power and status in society, right? So we prosecute, people who tend to be, minorities or poor for certain crimes and not white and wealthy for other crimes. And all the legal representation in the world isn't going to change the fact that certain people in this society have power and status and influence and other people don't, right? So I think that is a perfectly valid critique. The thing that I would say is I think if you go down the road toward my proposal, you don't solve those other problems, but you start to you shine a light on them and start to make you add friction to the ease with which we now do that kind of thing. And what I mean is if suddenly the kid that you were going to send away for 10 or 12 years for some nonviolent drug offense has a legal team of not Jeff Skilling-esque talent, but a very competent, a very able legal team, they're going to be able to call the state on this.
Right.
I mean, they're going to be able to flex some muscles in ways that that the kind of the poor kid now puts up no fight at all, right? I mean that it's just a kind of open and shut proposition. So I think
right. I mean the reason why the state can get away with sending so many poor and minority people to prison for drug offenses is because there's nothing that gums up the works down the road, essentially.
That's exactly.
They start with there's a poison. I guess the tree is poisoned and the fruit falls off that, but there's nobody to come along and say, "Hey, this is a poison fruit."
That's exactly right. Yeah, I would say one of two things happens basically, right? If this kind of proposal were to go forward, either because now everyone is being funded at the same level, essentially their legal defense in these cases. So either it's funded at absurdly low levels, right? And then suddenly affluent people are like, wait a minute, I'm only going to be able to, if God forbid I somehow got busted for marijuana possession or something, and you're telling me I can only spend like $500 on if we fund it at absurdly low levels, the affluent people are very quickly going to pipe up and say, hey, that's crazy. If I somehow get busted for this, I want to be able to spend way more. So then you can imagine immediately a political constituency for increasing spending. And if we fund it generously, then we have this gum up the works phenomenon where poor people can suddenly start pushing back with a lot more muscle than they've ever had before. So
and you've also found at least a partial cure for affluenza in that situation.
That's right.
But we should also say that in the context of civil cases, this would have, I think, even even more clearer impact, because then you have sort of all of the problems that we're having with sort of the regulatory framework in this country become enhanced. You seriously diminish corporate power and ability to sort of play fast and loose with consumer protections, with labor protections, et cetera.
That's right. No, no question about that. Well,
it's a fascinating piece. I mean, I hope I'm alive until the day that something like this gets instituted. But it really is a great idea, and I think you should write a book about it, frankly. But
well, thank you. That's very generous. Yeah, it's interesting. I got the idea initially because I did a piece last summer for the New Republic about big law firms and what it's like to work at one and how they work and how they're basically their whole business model. And the more I got into that piece, the more I thought, well, this is crazy that we basically take all this legal talent and we make it available to 1% of the population. It was just outrageous. And as I was finishing that piece, I couldn't sort of get this idea out of my head that if the Martian came down and looked at this, not knowing any of the sort of history and not taking anything for granted, that they'd think it was just utterly preposterous.
Yeah, I mean, it is amazing the amount of firepower that's involved in this, where you've got, Harvard Law graduates working on a paragraph of someone's defense.
That's right.
Whereas, someone who's going, someone else will have maybe just an hour of an attorney's day who's got, 40, 50, 100 other clients to deal with that day. It really is, I think, a stunning disparity.
No, it absolutely is. And I don't want to sort of dump on public defenders. A lot of these people are very talented people. Many of them went to top schools too. But as you say, I mean, if the caseloads are overwhelming them, then even a sort of heroically capable lawyer is just going to have to cut corners. So
absolutely. Absolutely. I mean, that's they're only human, and they're trying to juggle, I guess 80 balls at a time, and it's that much harder. But it's a fascinating piece. We will put a link up to it at majority.fm. Noam Schieber, thanks so much for your time today.
Thanks for having me. I enjoyed it.